Welcome to Q&A practice. We'll get started with plaintiff attorney. Ready? Here we go. You were a receptionist with Popular Mechanics during the fall of 2005, is that right? Yes. And what kind of relationship did you have with Sue? In other words, did you and Ms. West have occasion to discuss matters of a more personal nature? Yes, we did. During the course of those discussions, did Ms. West ever describe for you a contact or incident that she had with the defendant, Mark Stevens? Yes. Could you describe first of all the words that she used, and then we will describe the circumstances surrounding that. So first tell us what she told you. After she was out there around October 10th, it was like about a week or so after that, she had stated to me that he had come out in a towel. He, meaning whom? Mark Stevens, had come out where? She didn't specify, she just said that he had come out just in a towel. All right, did Ms. West describe for you anything else about that? Any other details about seeing Mr. Stevens in a towel? I just said really, and she said yeah, and she said yeah, and she laughed and just said kind of yuck, okay. You said kind of what? Yuck, yeah, just that. I guess not in a positive way. Not in a positive way, no. Did Ms. West, or was she seeming to describe a specific event? In other words, was she remembering that event when she was describing it for you? Yes. At least as far as my offer of proof, the rest is argument. I don't have anything further from Ms. Scott for this offer of proof. Mr. Austin? Hi, do you think this was a week or more after October 10th? Yes, that I talked to her. I don't know when the incident exactly was. Okay, but you're probably talking to Sue West October 17 or sometime shortly after that. Yes, she did not say that this had happened on October 10 or any specific date. She did not specify the date. No, she didn't call you to tell you about this incident. Not specifically, no. It just came up in conversation. You were chatting with her. Yeah, the reaction was, yuck, yeah, it was unfavorable, yeah, and then she sort of laughed it off. Right, this was 15 seconds of conversation. I would say yes. How long was the phone call? Roughly, altogether, probably a couple minutes at that time. What sorts of other subjects did you two cover in that conversation? Probably just work-related. I don't really remember all the details of the conversation. I just remember her saying that. Do you remember whether she called you or you called her? I think that time she called me. Probably she had a question on one of her photos, I think. Okay, so she had some more immediate work purpose for the call. Yes, and the two of you got sort of chatting, and this is one of the things she brought up, right? She did not give you any sense of time on when this had occurred. No, she did not. Okay, thanks. That's all I have. Judge, one follow-up. In the interim, that is between October 10th and October 17th, or really around that period of time, would you have these kinds of conversations often with Sue? Personal, chatty conversations? Pretty much every time she called in. I talked to her a couple times a week because I sent out the photo leads and everything, so we talked quite a bit. That's all I have. If we could excuse Ms. Scott, Judge, then I'm prepared to make my argument. All right. I just have a couple of follow-up questions. You said that the conversation took place a week or so after October 10th. Yes. And is it your understanding that October 10th is the day that she was describing that this happened? I really can't say for sure. All right, so you don't know if she was talking about a visit to Mr. Stevens' property on October 10th or at some previous unspecified visit? Yeah, I would not know that for sure. And do you remember how the comment or what prompted the comment, what background conversation led up to it? I don't really remember, no. I just remember we used to talk about different things that had happened during our day that were unusual or funny or different customers and things like that. So, all right, you are excused from the courtroom for a few minutes. Mr. Morris. Thank you, Judge. As this court knows, this statement is being offered pursuant to the hearsay exception of a statement of a recent perception. It is important, Judge, to note that different admissibility standards for recent perception compared to present sense impression or even excited utterance where time is important, that being time, the time-sensitive nature. Because of the nature of this particular conversation, it's clear that the three factors that are required for recent perception have been established. First of all, the issue of whether or not the event or condition that's being described was recently perceived is a factor, but recently is in a much broader term. 1988 Court of Appeals decision of Kluver versus Evangelical Reformed Congregation, cited at 143 Wisconsin 2D 806, was an 8 to 10 week period between the event and its description. The recent perception admissibility theory was satisfied by that 8 to 10 week period. But here, Judge, I think we can infer that because it only occurred a short time after the October 10th meeting, that it was of recent perception, at least more recent or recent enough to satisfy that particular prong. Again, Judge, the statement, or secondly, I should say the statement must be made where the declarant is recalling something clearly and that it's not in response to some litigation or investigation. The second and third prongs aren't really, I believe, at issue in this case, so I believe the state has met through this offer of proof the foundation under 908.0452 with the declarant, that is Ms. West, being unavailable. That is a statement of recent perception, and would ask the court allow its admissibility. Mr. Austin, thank you, Your Honor. I agree that if this statement fits anywhere, it would fit under section 908.0452, Wisconsin's unusual, I think, not taken directly from a uniform rules of evidence or model rules of evidence, but Wisconsin's exception for statements of recent perception. Clear out the underbrush first. If there's no gainsay in the fact that Sue West is unavailable, so the state meets that threshold requirement, and I, like Mr. Morris, view this statement as not in contemplation of litigation. I have no reason to question Sue West's recollection being clear at the time, and this statement was not in response to instigation of a person who was investigating or litigating a claim, so the question does not down to the recency requirement. Going to go back up just a little bit, if you think about the basic rationales of hearsay exceptions, most of them are either because the out-of-court statement is of a type that's very reliable, and courts have recognized that over the last several centuries, or that the hearsay statement is of a type where we have a high necessity to have something like that, and of course, reliability and necessity are not poles. Get back to that one. And now we'll start this new transcript. And we'll start with the court. Ready? On the record, this is the time and place regularly set for the hearing in the matter of the accusation against 7-Eleven Inc. and Austin Inc. doing business under an off-sale beer and wine license at 7-Eleven store number 20541524. One at premises located at 2115 East Rose Boulevard in West Hills, California. The case is before the Department of Alcoholic Beverage Control and bears file number 2038786 and registration number 070436338. Good afternoon. My name is James Owens. I'm an administrative law judge assigned by the department's administrative hearing office. May I please have the appearances of the parties, commencing with the department. Thank you, Beth West, for the Department of Alcoholic Beverage Control. Good afternoon. Good afternoon. Good afternoon, Michael Morris. On behalf of the licensee, good afternoon, Mr. Morris. Prior to our opening the record, I marked a package of documents as Exhibit 1. Counsel have had an opportunity to review the package. Unless there's an objection, I'll receive Exhibit 1 for jurisdictional purposes. No objection, no objection. Thank you. 1 is received. Will the parties stipulate that all jurisdictional requirements have been met? So stipulated, yes. Any and further that the type of license in question is a type 20, an off-sale beer and wine license issued to respondents on June 29th, 2001 as set forth in the accusation, so stipulated. Your Honor, I won't be able to stipulate to that. The only reason why is that this particular location has been licensed since '88 actually, and the only change that's occurred which caused there to be a transfer of the business ownership form was from an individual to a corporation, but it's the same person who was the licensee at this location prior to 2002 is now the corporate officer and a corporation. All right, so that's fine. Will the parties stipulate that there is no record of prior departmental discipline against this licensee, against this particular license number? That is what I said. I would stipulate to that. Mr. Morris, yes. All right, then that stipulation, the type of license is received. There's no stipulation concerning its date of issue. Mr. Morris, did respondent subpoena the district administrator? Yes, Your Honor. Do you have an offer, a written offer of proof and brief? Yes, I do, Your Honor. Want to bring those forward? And I will incorporate these by reference, please. All right, the documents collectively will be marked A for identification. Let me ask you, Mr. Morris, are there any new arguments in these papers that I haven't heard before? No, you have heard the contentions which are raised in the brief, so the answer is no. No new arguments. The answer is no. All right, I've heard it before. You don't need to reiterate it here. A will be in the record. I'll consider the offer of proof as having been made, and as I have done before, I'm going to quash the subpoena and just with the statement that I have the department's recommendation is simply that a recommendation. I'm not bound by it. I have the evidence that will be presented here at the hearing. I have Rule 144 and the argument of the parties given here today to guide me. The inner thoughts and feelings of the district administrator are not relevant to me. Does either side wish to make an opening statement? Ms. West, Ms. Wood, or excuse me, Ms. West? No. Your Honor, Mr. Morris, no opening, Your Honor. I think I know we all do this at every hearing, but I'd just like to make the record perfectly clear that my understanding is that the department objected to the subpoena of the district administrator on, and specifically the department's objecting to. I haven't heard an objection from the department. I didn't ask for an objection from the department. I am quashing the subpoena on my own motion for the reason stated. Okay, and the reason is the one that you stated on the record, and it is not the service of the subpoena that's at issue, correct? I didn't inquire into that. Okay, all right. No opening, Mr. Morris? No. In an accusation, the burden's with the department. Ms. West? Thank you. My first witness is Mark White. Please come forward. Raise your right hand. Please be seated. State and spell your name for the record. Mark Ryan White, MarkRyanWhite. Thank you, Ms. West. Thank you. Mark, what is your date of birth? May 4th, 1986. And did you say 86? Correct. On March 21st, 2006, were you working as a decoy for the Department of Alcoholic Beverage Control? Yes. How old were you on March 21st, 2006? 19. All right, that will conclude our Q&A practice.